for that. And, good morning, everyone. As Marty said, my name is Sara Mosadeq. I'm a lawyer here at Devry and as he said, I'll be talking about increased general damages awards in the Human Rights Tribunal in the MeToo era. So let's get right into it. What is MeToo? So MeToo is a movement that commenced in October of 2017, and it's a movement against sexual harassment and sexual abuse. The term was first coined by a social activist by the name of Sara Mosadeq in 2006. And Sara was a social activist who commenced a campaign to raise awareness against sexual assault and sexual harassment. In 2017, October, an individual by the name of Alyssa Milano, who's a well-known actress, also used the term in a tweet, and it was to raise awareness against sexual harassment, especially as it relates to the workforce. Now, although the hashtag is predominantly used by women, it is used by all genders, in fact. So, what happened in October of 2017? The individual that's on the PowerPoint, that individual's name is Mr. Harvey Weinstein. Mr. Weinstein is a well-known American film producer, and he was on the board of directors for the Weinstein Company. In October of 2017, the New York Times published an article in which several dozens of women alleged that Mr. Weinstein had either engaged in sexual abuse, sexual assault, and even rape in certain situations. Now, the allegations were also that individuals within the Weinstein Company and very high up individuals were aware that Mr. Weinstein was engaging in this conduct and either didn't do anything about it or in some places actually condoned it. Currently there's about 80 women who have come forward, and there was initially a set, and then since the article came out, a number of other women have also come forward. Mr. Weinstein has obviously since been charged with rape and a slew of other charges. He's obviously no longer on the board of directors for the Weinstein Company. And in fact, the Weinstein Company was subject to several lawsuits, and they, in March of 2018, were bought out, and it's actually now called Lantern Entertainment, and the Weinstein Company actually no longer exists. So what is the Ontario Human Rights Tribunal? The Ontario Human Rights Tribunal resolves claims on the basis of discrimination and harassment brought under the Human Rights Code. In terms of financial compensation, the HRTO can provide compensation for general damages, and that's to award damages for injury to dignity, feelings, and self-respect as a result of any discrimination that has occurred, and also special damages for any out-of-pocket expenses actually incurred by the complainant. Prior to 2017, the HRTO generally awarded damages in the $10,000 to $20,000 range for injury to dignity, feelings, and self-respect. The highest at the time was the case of Smith and Menzies Chrysler Incorporated, where the award was $50,000. In that case, Smith was an individual who worked at a car dealership, and he complained that another co-worker on several occasions made sexually degrading comments and in fact exposed himself to the co-worker, to Mr. Smith, sorry. And Mr. Smith also alleged that the owner of the dealership was aware that this was going on and either turned a blind eye or sometimes actually even engaged in some of the sexually degrading comments. It's important to note that despite the fact that the award was $50,000, Mr. Smith never actually alleged that he was touched or sexually assaulted in any manner. It was simply the comments and the exposing that resulted in that award being granted. Now, then we come to OPT and Prestige Foods Ltd. Now, this case was also decided prior to the MeToo movement. It was decided in May of 2015. This, prior to the current time, was the highest award that was ever granted by the HRTO. They granted $150,000, which was 3 times more than the Menzies case. And the general damages were awarded both against Prestige Foods Ltd. And the owner, Mr. Jose Pratas. So Prestige Foods and its owner, they operated a fish processing plant. they hired migrant workers, and two of those migrant workers were two sisters, OPT being the complainant, and her sister MPT. OPT was a migrant worker from Mexico, and after being sexually assaulted numerous occasions by Mr. Pratas, she filed a complaint with the HRTO on the basis of those sexual allegations. Now, in the evidence that came out, and they were actually quite severe, OPT complained that Mr. Pratas inappropriately touched her, both over and under her clothing on a number of occasions. He also forced her to perform fellatio and forced her to engage in sexual intercourse on a number of occasions. And it was all done under the threat that he would deport them or have them deported back to Mexico. And so they felt like they had no other choice but to do it. OPT's younger sister goes by MPT. She also complained that she was subject to the sexual abuse. She complained that Mr. Pratas inappropriately touched her on her first day of work, and on a number of occasions asked her to engage in sexual intercourse. And she obviously refused that. And according to the tribunal, Mr. Pratas' conduct was unlike any they'd ever seen before. They never had a case where the allegations were as significant as they were in this case. And because Mr. Pratas had both a level of control as an employer over these individuals, but also because they were migrant workers, they were seen to be in a very vulnerable situation. And because of those circumstances, the tribunal awarded $150,000. Now, there have been other cases in other jurisdictions where, for example, the British Columbia Human Rights Tribunal, where an award of about $75,000 was granted in 2013. There was also an award at the Alberta Arbitration Tribunal where there was an award of $125,000, again in 2013, in relation to a worker who was subjected to rat poison. So there have been higher awards, and a lot of people and legal practitioners and lawyers considered Prestige Foods to not be the precedent setting. They figured it was a unique situation. It wasn't something that they expected would come up again, and that high award that was given in Prestige Foods would not carry forward. And that does ring true because throughout 2016 and 2017, the HRTO continued to award damages roughly in the $10,000 to $20,000 range. So they had gone back to what they had been awarding prior to Prestige Foods. So then comes 2018, and now we're post the MeToo era, where a lot more awareness has come out in relation to sexual assault, especially in the workplace. And the movement itself is the promotion of having people come out and feeling comfortable to bring these allegations forward. So 2018, we see two very precedent-setting cases, and that is AB and Jos English Ltd, where a general damages award of $200,000 was awarded, and GM and X Tattoo Parlor, where a general damage award of $75,000 was awarded. Now, AB and Jos English Ltd is the largest award that's ever been rendered by the HRTO in the amount of $200,000. It was rendered by Vice Chair Don Kershaw in January of 2018. And again, the award was both against the company and the owner of the company, the individual who engaged in the sexual misconduct. Now, in AB and Jos English Shoes, the complainant was a single immigrant worker, again, an individual who seemed to be vulnerable. And AB worked in the downstairs shoe store, but she also rented the upstairs apartment from a company that was controlled by Mr. Paul Singer. Mr. Paul Singer is the individual who is alleged to have engaged in the sexual misconduct. The complainant AB stated during the hearing that he sexually harassed and assaulted her both while she was at work downstairs, but then he would also come upstairs into her apartment during non-working hours, and he harassed her there. She also said that he made fun of her language and her body, and he also made inappropriate comments about her place of origin. She also complained that he would threaten her and told her that if she ever, complained about this or let anyone know, that he would have her deported and sent back. Based on the findings and the severity of the allegations, the HRTO determined the $200,000 was a reasonable award. Again, it was a situation where not only was he harassing her while she was at work, but because he had access to her after hours, it was the apartment right upstairs above the store, and she was getting harassed in her apartment as well, and because she was a single mother, she was also a migrant worker. All of those factors rendering her to be in a very vulnerable position is why the HRTO awarded the significant award. Now the next case is GM X Tattoo Parlor. In this case, it was decided in February of 2018, and the complainant sought $75,000 in damages, and the HRTO awarded that amount. Interesting to note that in this case, the individual who committed the sexual assault, criminal proceedings were commenced against him. He actually pled guilty to a number of charges, including sexual assault, invitation to sexual touching, and sexual interference. So because he had essentially admitted to many of the allegations, the only issue that the HRTO needed to determine was the number of damages that would be granted. The facts in this case, GM, being the complainant, was a 15-year-old unpaid intern, which is also important to note because unpaid interns obviously also have the same protection. And the individual who was accused of doing the sexual assault and actually admitted to it was both the boss at the tattoo parlor, but was also actually a family friend of the young girl. And she worked at the tattoo parlor because she wanted to get into her desired field. She liked art and sort of her first intro into a work environment. She complained that he engaged in sexual conversations. He touched her inappropriately and asked her to engage in sexual intercourse in exchange for some money and a tattoo. As a result, the minor, during the hearing, it was revealed that she had some very significant psychological effects and trauma as a result of having been abused. And the tribunal took that into consideration as well. And based on the fact that he had already admitted guilt in the criminal proceeding, the tribunal awarded $75,000. Now, what does this mean for employers? Well, first, the Me Too movement, the emphasis behind it is to create a comfortable space and a space where employees or anyone else who has been the subject of sexual assault or harassment, for them to come forward. So are we likely going to see more cases come forward? Yes. In conjunction with that, the awards will also increase. We've seen just in 2018, two very significant awards have been handed down. One is $200,000, which is the largest, and $75,000, when in previous years we were looking at $10,000 to $20,000. So it'll increase both in the number of cases and in the manner in which they're dealt with by the HRTO. So how do employers respond and deal with these sorts of issues? Well, first, employers need to understand what constitutes sexual harassment. You would think maybe something as innocent as touching an employee on the shoulder, or, we're all aware of the more significant allegations, but something as simple as a pat on the back could amount to sexual harassment. So if you're not aware of what sexual harassment entails, or harassment in general entails, then you should speak to a lawyer and get some legal advice and make sure that you're aware of what is covered by that area. The other thing that employers need to do is you need to ensure that you have a workplace policy in place, both as it relates to sexual harassment and other types of harassment. It's very important. Every workplace is required to have one, so if you do have employees, you should have a workplace policy in place. If you don't have one, I would strongly recommend that you do get one, and obviously there's lawyers here that can assist you with that as well. And lastly, it's important to note that employers need to start taking complaints like this seriously. What you might have brushed off and said, oh, he was just joking or she was just messing around, it's not the norm anymore. We're going into an era where these complaints, regardless of how trivial you might think it is, are being taken seriously, and the complaints are going to come out more, and employers need to know how to respond to a complaint and how to deal with them. And as you've seen in a lot of the cases, especially with Mr. Weinstein, the significant allegation was that not only was he doing it, but very senior members of the Weinstein Company were aware of what was going on and turned a blind eye. And it's not okay for owners or employers who might be aware of something and say, you know what, it's not that important, I'm not going to deal with it until it becomes a big issue. You need to, in essence, you need to nip it in the bud when you see it. And so it's important to know what actually is encompassed in sexual harassment and ensure you have the correct policies in place to deal with an issue like that. Thank you. That concludes my presentation, and I now have the honor of letting everyone know that it's break time. So there's food and snacks and coffee and drink for everyone that's here, and we will reconvene probably in about 10 to 15 minutes. Thank you.